In this video, we're going to have a look at how the rules around freedom of movement into the country have changed. On the 1st of July, the new rules resulting from Brexit came into full force. This impacts us as property owners, as under the Immigration Act, we, or the agent we use, has to carry out a right to rent check on all potential tenants. Failure to do so, or renting to someone who does not have the right to reside, can result in both civil and criminal fines and even a prison sentence. And it's interesting to note that these rules do not apply in Wales, Scotland or Northern Ireland. Brexit has meant there's no longer freedom of movement between the UK and Europe to live and work in other countries without a visa. There are still lots of reasons why people can come to live and work in the country. For people wanting to work here, there are new rules to comply with, and I'll go into that in a bit more detail in just a minute. As ever, people are welcome to come to the country to study. Despite coronavirus restrictions, we've seen more international students recently than we might have done in the past. I'm not entirely sure why this is the case, but we are seeing more and more students coming to study at regional universities such as Warrington and Preston. People with student visas may have the right to work, although this is usually limited to, say, 20 hours per week, so you'll need to take a view during referencing if they'll be able to earn enough to pay the rent, or if they have financial support from family or a bursary, for example. People may still come and live here if they already have family here, or a Commonwealth citizen with a right of abode. A new category is that of British national overseas, which applies to many residents of Hong Kong. Since the changes in laws imposed by China in January of this year, we've seen an influx of Hong Kong residents relocating to the UK. In fact, we've just moved a new family in over the weekend. With a BNO visa, they can stay for 5 years, after which they can reapply, and they can also apply for citizenship in certain circumstances. Most people who are applying to rent from us will now have a skilled worker visa. This replaces the old Tier 2 work visa. To get this visa, they must jump through quite a lot of hoops, including have a confirmed job offer by an employer, and this employer has to have been pre-approved by the Home Office. They also need to have a certificate of sponsorship from that same employer. They need to be doing a job that's on a list of eligible occupations, and again, this list is available from the Home Office. They must be paid a minimum salary dependent on the role they will be doing. They must be able to prove a minimum level of reading, writing, speaking and understanding English, and there are various ways in which they can do this. They must pay an application fee for the visa as well as an annual healthcare surcharge, although in some instances their employer may cover these costs for them. And finally, they need to be able to demonstrate that they have some savings. Once a visa application has been approved, they'll be able to stay for up to 5 years, at which point they can apply to extend the visa, or if they're eligible, apply for indefinite leave to remain. Whilst people are here on a work visa, they can't claim benefits such as a state pension, nor can they change employer during this time. The other types of long-term visa are for healthcare workers, people transferring here with an overseas employer, a minister of religion and a sports person visa. All have similar qualification criteria. For us, we're seeing an influx of people from Commonwealth countries with a healthcare visa coming to work in the NHS. After an initial induction, they are given a 3-year fixed-term contract on a starting salary of around £21,000. This income is more than sufficient to meet the rental cover test we apply to people wanting to rent a HMO room from us, although in many circumstances they're actually sending quite a large proportion of this money home to their family. With these changes that came into force on the 1st of July, our European friends who used to come speculatively to the country to get a job through an agency to work as a warehouse operative, for example, unfortunately can no longer do this. Warehouse operative is not on the list of eligible occupations, and yes, I did check. This role does not meet the minimum salary criteria, and many of our tenants who arrived under the freedom of movement rules could not speak very good English, nor in many cases did they have any savings. There are far too many to mention other temporary and miscellaneous visas which are also valid. If you happen to be presented with one of these, I recommend you check out the rules on the government website or phone the Home Office helpline. Under the new rules, people who are already living and working in the country that entered under EU freedom of movement rules now have to successfully apply to the EU settlement scheme, and they needed to have done this by the 30th of June. Under the EU settlement scheme, depending on their circumstances, they will have been granted a limited right to remain called pre-settled status. Once this limited right to reside expires, they need to reapply to the scheme to remain in the country. Alternatively, if they've already been in the UK for many years, they may have been granted settled status, which gives them unlimited right to reside. After a certain length of time with settled status, people can apply for citizenship. Unless people qualify for certain exceptions, EU citizens who have not applied and do not have any type of settled status no longer qualify for right to reside, and therefore you'd be breaking the law by renting to them from the 1st of July. Fortunately, checking someone's status is now easy using the government's online check-in system. For this, all you need is your prospective tenant's name, date of birth and a share code. They can obtain a share code from a government website once they've successfully applied to the EU settlement scheme, which they give to you. The results come back fairly quickly, sometimes same day, and this gives you confirmation you can rent to this person. And here's what a Home Office report looks like. So effectively, you now need to check someone's immigration status, not just their national passport. I find the government check-in service quick and easy to use, although you don't have to use this service and you can't actually compel somebody to give you their share code as part of your rental application. The person you are checking can offer to show you their original documents instead, which might include their passport, a letter from the Home Office or a biometric residence permit. The full list of documents that are acceptable for both limited and unlimited right to rent checks are available in the government's document Landlord's Right to Rent Checks, and this is available from the government website. So I'll leave you with my contact details if you've got any questions about right to rent, property management in general, or you want to find out more about our training and education services, please get in touch.